This, ladies and gentlemen, dear audience, dear viewers, brings us to our next session. As we announced our privacy conference this year, we put a lot of emphasis on the fact that we included voices from all parts of the globe. So I'm very happy to have Miriam Wimmer now with us. She is the head of the Brazilian National Data Protection Authority. Miriam, I hope you forgive me for not trying to pronounce it correctly in Portuguese. It will be fine in French and Spanish, but Portuguese I will not try today. But thank you so much for taking the time. I mentioned earlier that Brazil is kind of an important and a very strategic partner in the global data economy, as well as in global trade as well, for Germany and for Europe, of course. We also heard that from our UK partner, so it's great to have you here today. And I'm glad to give you the floor to maybe open the session by talking us through the recent developments that you have been seeing that have been happening in Brazil.
Great. Thank you so much, Rebecca, for the invitation. I'm delighted to share some information on Brazil with an international audience. I also apologize for not speaking in German. My grandparents were German, actually. I know I have a very German name, but I'm in fact Brazilian and currently working as one of the 5 directors of our National Data Protection Authority. So I think it would be interesting perhaps to go over some of the developments over the last year. And in fact, I think perhaps the most important development took place last September, on September 18th, when our general data protection law finally came into force after almost 10 years of discussion within National Congress. So Brazil is quite a latecomer to this debate internationally, because although Europe has already 50 years of debates on personal data protection, this is still something fairly new for us. So at this point in time, there's still lots of open questions, I think, related mainly to the need of creating a harmonized interpretation of our general data protection law vis-a-vis the many other sector-specific laws and general laws that also apply to some aspects of personal data protection. Before LGPD was approved, we already had some provisions on personal data protection in our constitution, for example, the right to privacy, to intimate life, the habeas data, which is also an important procedural mechanism for having access to data held by public databases. We have our general consumer protection code, which also had some provisions on personal data. We had rules on elections and healthcare and telecommunications, on the financial sector. So our approach was quite fragmented, I'd say similar to the USA in some aspects. And now finally, we have this general data protection law with uniform provisions that apply both to the public and to the private sector. And we have this newly created data protection authority that somehow has to interpret this complex law and also create a very constructive relationship with other governmental bodies that already were acting in different fields of data protection, although they did not have this specific mandate. So it's a very interesting and very challenging period. And in fact, I think when we look at our general data protection law in Brazil, there are many, many, many commonalities with the GDPR. In fact, our law was very strongly inspired by the GDPR. There are some minor differences. We can go into that later on if you think it's interesting, Rebecca. But I think in general, it's important to state that we also have an ex-ante approach towards personal data protection, which means that we have a broad concept of personal data as related to identified or identifiable individuals. We have a number of legal bases that allow data to be processed in a fair manner. We also have a number of principles that are very similar to those we find in the OECD privacy framework and also within the GDPR. And I think also we have a number of data subject rights, which basically incorporate the basic ARCO rights: access, rectification, cancellation, opposition, and so on. So if you look at the big picture, it's very similar to the GDPR. I think our legislation also has this role of trying to create bridges between these different aspects of personal data as economic assets that are very important in terms of innovation, economic and technological development, but on the other hand, also recognizing personal data protection as a fundamental human right And this is something that is, I think, very new in Brazil. We very recently had a decision from our Supreme Court here in Brazil concerning a census, in this sense, quite similar to what happened in Germany. So we had a decision on a census law, and our Supreme Court finally recognized that there is an autonomous fundamental right to data protection, and this thus creates an obligation of protecting this right for the government itself. So I think an important part of this huge complex framework is, of course, the National Data Protection Authority. And we have in Brazil now our Autoridade, Nacional de Proteção de Dados, our National Data Protection Authority, which was actually created a few months after the law came into force. So it's a very challenging situation because the law was in force in September and we were only formally created last November. And we are, in fact, still a very small organization. Currently, we have, I think, 47 staff members, and this includes the 5 directors. This includes our interns, our trainees. So it is, in fact, a very small organization. And I think it's interesting to note that we are headed by a board of directors. So our decisions all have to be worked out between us. We have to reach consensus or a majority in terms of votes. And we have a structure that is currently still connected to the presidency of the Republic, which means we do not have full independence as DPAs in Europe do, but we do have certain guarantees in order to allow us to decide autonomously. So we have autonomous decision-making powers. Our decisions cannot be reviewed by other governmental bodies, only by the judiciary branch. We also have a certain freedom in terms of building our staff members, although we do not have a specific career within public service geared towards ANPD. We can request different civil servants from different organizations. So we are gradually, starting to build up this very complex legal framework towards data protection. And I think that when you look at the role of our DPA, it is a role that is very similar to what we see in Europe as well. So we have, of course, a central role to play in terms of protecting rights, and we can do this through issuing regulation, through monitoring, also through the application of sanctions, not only fines, but also sanctions in terms of prohibiting certain data processing activities, warnings, also the name and shame approach, so we can publicize a certain infraction in order to make sure everyone is aware that this happened. We also have the responsibility of interpreting the law. And I think this is a very important responsibility. When you look at Brazil, we have a federative structure. So we have 27 states, 5,500 something municipalities, and ANPD, in fact, is the central body responsible for providing final interpretation of the law in the administrative branch. So of course, the judiciary can review this, but we are responsible for sort of stabilizing the interpretation, providing coherence and consistency throughout our very, very large country. We also have an important educational role. So we have, in fact, over this almost 11 months, been working hard in issuing guidance, providing also information for data subjects and for smaller organizations. And finally, we have an important role in terms of international engagement. And I think this is a bit different from the European context because in Europe, you have the European Commission coming up with adequacy decisions. And in Brazil, this is actually up to the DPA. So we are responsible for approving standard contractual clauses, binding corporate rules, and also for issuing adequacy decisions and coming up with the elements that will be considered when we look at other countries in terms of adequacy. So it is a very complex and a very challenging role, with different aspects of our behavior that have to be further developed, I think. And at this point in time, as I mentioned, this is still a very, very new topic in Brazil, because in fact, unlike Europe, we did not really have a personal data protection culture in the country. I think it's an issue that has been gradually gaining more momentum, raising more awareness. We did have some very unfortunate and very big data breaches in the country at the beginning of this year. So I think gradually we are beginning to see family members and friends not involved with the data privacy discussion becoming more aware of this issue. And I think that as we look forward, perhaps one of our main challenges is, in fact, to work on creating this new data protection culture and also raising awareness within other different governmental bodies and creating these constructive relationships that will allow us to work in a constructive fashion towards implementing this legislation. So I think, Rebecca, I'd like to stop at this point because I'm sure you have many interesting questions, and then perhaps we can guide the discussion towards points that are more relevant to the audience. Thank you very much.
Thank you, Miriam. I do indeed have so many questions in my hat, but thank you first of all, because I think you gave a very good overview about what is happening, and I found the approach, the structure of your data protection authority quite interesting, because it's of course different from what we have here in Germany. But let's start at the beginning. We'll have to circle back a bit. You already mentioned that you kind of drew, or you got inspired by what the GDPR entails with regards to rules and rights and requirements, but there are also a few differences. Maybe you could elaborate on that a bit, because I guess they go beyond those structural differences with regard to the DPA setup.
Right. So I do think it's important for us to highlight these differences, but also focusing on the commonalities, because in fact, our approach is, mainly similar to the European approach. And I think these are minor differences that can, very easily be worked around. So to begin with, the GDPR has 6 legal grounds for data processing. And in Brazil, we have a larger number. So we have 10 legal grounds. Most of these, I think, can sort of be they can somehow be taken back. There's a correlation with the GDPR. So for instance, we have the protection of health, and in the GDPR, you have slightly different wording, but I think generally they follow the same spirit. I think perhaps the main difference is that we have a legal basis that allows data processing for the purpose of protection of credit. And this is something that in Europe, I believe, would usually be done under legitimate interests. And here we have a separate legal basis for that. So I think that's an interesting point. We also have the legal basis of studies by a research body, exercise of rights in legal proceedings, health protection, but I think they are generally quite similar to the spirit of the GDPR. There's nothing that really is so different from what you're used to seeing in Europe. There are also some minor differences in terms of access rights. So as I mentioned, we have the basic ARCO rights. I think it's important to mention that both GDPR and LGPD state that data subjects have rights such as data access, portability, correction, even deletion. And the main difference here refers to the deadline for fulfilling these data rights, because LGPD says that companies have 15 days to respond to an access request. And if I'm not mistaken, under the GDPR, the deadline is 30 days. But this is something that is still open to further regulation. So I think it's also something that we will gradually be able to, create greater harmonization in our approaches. Another interesting difference is that under the GDPR, not all organizations are required to appoint a DPO. I believe only those that have large-scale data processing. And in Brazil, our approach was a bit different, because in fact, Congress decided that all organizations have to have a DPO, but that the ANPD may provide for exemptions, considering the risk, considering the volume of data processing activities. So at this point in time, we have still not yet approached this issue. So I think this is something that raises some concerns, especially for small organizations who are perhaps not in a position to have so many staff members or such legal expertise to deal with, having someone taking up this role of a DPO. But it is something that we are working on. And I believe that as we move forward, we will be able to come up with clearer elements to understand what is high risk, what is large scale data processing. And of course, the European approach is an important source of inspiration. There is a difference in terms of fines. Our fines are not as significant as the European fines. So we are allowed to fine companies of up to 2% of the company's revenue in the previous year, limited to 50 million reais. 50 million reais is approximately 10 million US dollars. So I guess less euros. But here in our national context, this is quite a significant amount. It's the same amount, for instance, that our telecom regulator is allowed to fine telecom operators. So there is, some similarities also with regulated sectors in the country. And finally, I think another difference refers to security incidents and data breaches, because the GDPR establishes a deadline of 72 hours to report these data breaches. And in Brazil, our law, in fact, did not establish this deadline. So it's up to ANPD to define. The law says that data breaches have to be reported within a reasonable time frame to the DPA and also to data subjects. So we're currently working on figuring out what is a reasonable time frame. We have suggested provisionally that this would be 2 working days, which I guess is quite similar to 72 hours. But this is still temporary advice. We still do not have a regulation on this point. So it's something to be further developed over the coming months.
Thank you. That is also very, very interesting. I'm still trying to understand the DPO rule. So you, as the supervisory authority, would be able to exempt certain companies from the requirement. But would the companies need to approach you, or do you approach them because you do some kind of market evaluation or assessment? Because what I'm really wondering is how you will be able to do that with 47 staff members.
Right. So this is not a case-by-case analysis. In fact, we are providing these guidelines in regulation. We have currently already had a public consultation on the draft regulation for SMEs, small and medium enterprises. And in this regulation, we have provided for some parameters that can be used to identify when a small organization does not have to comply in full with the rules provided for by law. So this involves not only the appointment of a DPO, but also, for instance, more flexible deadlines for reporting data breaches, more flexible rules in terms of data protection impact assessment, and other similar issues. So we have suggested some parameters. These include, for instance, if the company is not processing sensitive data, if it's not a large-scale processing activity. There are a number of parameters that we have suggested to go through public consultation. And in this case, it will be up to the organization itself to determine if the rules apply or if they do not apply. We will certainly not be going out on a case-by-case basis saying, you're in, you're out. This would, of course, not be feasible with a small organization. So we are building upon the idea of accountability and, responsibility for ensuring compliance with the law that is up to the organizations themselves. And we will be providing these broad parameters, and then the organizations will be able to define if they are or not subject to those legal requirements.
All right. Yeah, that sounds a lot more sensible. Everything else, I guess, wouldn't work anyway. As you already mentioned, data protection is kind of a new right. So do you already see some kind of cultural change happening also in the administration or in the private sector, so in businesses? Because you mentioned that there is some change going on in society. People are more aware that they do have those new rights. But do you also see a change happening on the controller side?
I think, Rebecca, that discussing this issue with our European counterparts, we feel that there is a quite similar reaction to what happened with the GDPR. So a first moment of panic, of rejection of the new legislation, where everyone thinks, my God, how am I going to deal with this very complex set of new rules? And then gradually people become more used to this topic and begin to have a greater understanding of the law. And we begin to see a more consistent pattern of implementation. So I think this is true also in Brazil. I think it's important to note that our law went through Congress during almost 5 years. And before that, there were discussions in government. So we have a 10-year period of debates leading up to the approval of the law. And then we had another period of vacatio legis before the law was actually in force. So I think during this period, there was time for organizations gradually to realize that the law applied to them and what they were supposed to do. But this is, I think, still work in progress. What we do see is that there are efforts to comply with the law, but there is still a certain level of misunderstanding or lack of clarity of what exactly needs to be done in order to achieve compliance. And I think this is also because ANPD was created, rather late. It would have been better for us to be created before the law came into force. So we are somehow, running very quickly to keep track with what's going on. But I do see that there is an effort, specifically within federal government. I see that many ministries are working on changing their internal procedures and reassessing their practices in terms of dealing with data protection. And also in Brazil, especially large organizations are already, I think, quite advanced in terms of rethinking the way they deal with personal data protection. Of course, this is particularly challenging for smaller organizations. And in our Brazilian economy, we do have a very large number of small businesses. So this is the reason why, in fact, in our regulatory agenda, one of the first issues we actually started dealing with was the issue of special regulation for smaller organizations. And I think it will be very important to provide greater clarity in order to also provide more legal certainty. One point I would like to mention, Rebecca, if you allow me, is that throughout all this process of creating rules, we have been working to be very transparent and to be very predictable in terms of not creating surprises or new rules that would somehow, create problems. So we did work on publishing our strategic plan, also our regulatory agenda in advance. We have been working on implementing this, and we have been holding public consultations, public audiences. We have been engaging with stakeholders, both in the private and in the public sector. So our idea is, in fact, to promote this larger discussion of the issue also among other stakeholders, because this is, I think, is very important in terms of raising awareness and also increasing the legitimacy and the acceptance of the rules that we are now establishing. So it's been a very interesting exercise listening to everyone and understanding the different perspectives on these issues that are sometimes quite controversial.
Yeah, I imagine they are. But I think that the last aspect you mentioned also kind of feeds into the educational role you mentioned earlier. And I think it's a very important aspect that Rdpa also has this educational function and wants to bring clarity and transparency. Maybe one other topic, Miriam, if you allow me to kind of change this, the subject a bit, or looking at the data protection framework in Brazil from a global scale, because as you can possibly imagine, international data transfers have absolutely been at the center of our discussions recently, not only but also at our privacy conference, of course. And there are a few countries that do have an adequacy decision. They were issued pre-GDPR, to be honest. So Uruguay and Argentina do have an adequacy ruling. Is that something you are working on or talking about with the EU Commission? Because as I mentioned earlier, Brazil is such a strategic partner for the EU and for global trade as well. So do you have thoughts on this as well?
Yeah, I think it's a great question, Rebecca, and it's one I also get asked very frequently here in Brazil. So I think during this first year, we haven't yet completed 1 year of existence. We're still, taking baby steps, but we have been working and trying to enter this international arena and figure out what our role is and how we can relate in a constructive manner to countries, to other countries, to partners that have systems that are similar to ours and also systems that are different to ours. So LGPD provides for a number of possibilities for international data transfers, very similar to the GDPR in this aspect. So there's the possibility of adequacy decisions, of safeguards such as SCCs, BCRs, approvals on a case-by-case basis. Also the possibility of transferring data internationally based on consent or the fulfillment of a contract. So we have a portfolio of mechanisms which relates, I think, very strongly to the European ones. And at the same time, we have a legal framework that is essentially inspired on the GDPR. So I think, of course, it makes sense for us to work closely with the European Commission in order to figure out if an adequacy decision is something that would be possible in the near future. And in fact, we do have a very good and constructive relationship with the European Commission, with the International Data Transfer Department. And they have, in fact, even through mutual cooperation, enabled us to take part in, capacity building activities. And, they've been extremely helpful in terms of assisting us also to interpret the law on our side. At the same time, I think adequacy proceedings are sometimes very lengthy proceedings. They take a couple of years. And in the meantime, we have to work on having other mechanisms that allow data to flow from Brazil and into Brazil in a very easy manner in order to facilitate international trade, for instance. So what we have established as a priority in a regulatory agenda is, in fact, working on our standard contractual clauses, because we feel this is a mechanism that is, sort of off the shelf, that can very simply be introduced into contracts between controllers and processors and enable data to be transferred, even if you are a small organization without, a huge legal staff assisting you. So we have been working on this. And of course, we are very much aware of the discussion in Europe, particularly after Schrems decision, Schrems 2 decision. And we have been looking at different models of standard contractual clauses, not only the European ones, but also in other countries, for instance, New Zealand, Singapore. We are trying to figure out what the best approach would be for Brazil, since we don't wish data to, be stuck in the country. We want data to flow freely, because this is an essential part of the digital economy. So digital free flow of data, but with a high level of data protection, I think is what we're aiming at this point. And I think also in the future, adequacy discussions with the European Commission will make lots of sense. But at this point, we're still working very hard on our domestic implementation, because as you can imagine, there are still many questions as to very basic concepts of the law. Who is the controller? Who is the processor? What does a DPO do? So we've been working on this at this point in time, but we do hope to make further progress in the near future.
That sounds like a really sensible plan, Miriam. Maybe allow me one additional question, because you touched upon the issue of capacity building, and you talked us through the structure you as a DPI do have. And this is something we have been discussing at length also in Europe, especially in Germany, because we have so many DPAs over here. And seeing how large Brazil is, how so many companies, so many administrative controllers you will be supervising, basically. Will there be additional funding for more staff at the DPA itself? Because in the European discussion, I always saw that we do expect a lot from our DPAs. We do want a lot of help and guidance, and of course they need to do their job properly. And at the end of the day, it comes back to are they able to do so? So are there enough people over there to do all the jobs they need to do? And do you see any capacity increase in the future?
I do, Rebecca, I do. In fact, I don't want to be overly optimistic, but we have been working very hard on consolidating our legal status, also going through a legal change in order to allow us to become even more independent from the central government. And this includes, of course, having more human resources and also more budgetary resources that are necessary for us to fulfill our legal obligations. This is something that, in fact, we included in our strategic planning. So our strategic plan has three main aspects. One is related to promotion of a data protection culture. The other is related to our regulatory framework. And the third one is related to our legal and institutional capacities. And in fact, I think an important aspect here is that Brazil recently underwent an OECD peer review on digital policies. And one of the OECD recommendations was, in fact, to reevaluate ANPD's legal status and provide the DPA with the necessary human and financial resources in order to allow us to fulfill our responsibilities. So I think it's always important to keep in mind that we are at the very, very early stages of a data protection culture in the country. I remember that when the directors were formally appointed last November, we were only 5 people in the meeting room, and now we are 50 people. So I think, some progress has been made over these past month, and I'm very optimistic that we will be able to continue improving the quality of our work and also the quantity of staff members in order to fulfill these very demanding and very important responsibilities that the law established.
I think actually it is amazing how far you've come already, seeing the short time span you had to do. You had to do all this and set up all the new structures and educate basically everybody about an inherently new right and new opportunities and new requirements also. So it's absolutely amazing to see that. I think we, on a global scale, we do see that GDPR was kind of an inspiration for many other countries, but I also always get that you are trying to do a few things differently, and you are learning maybe from our mistakes, if I might say so. So it's great to see that. I'm hoping that we'll keep in touch, Miriam, and to continue the discussions. I absolutely, I wish you success and good luck in everything you envisage to do over there, and for the new DPA as well, and your colleagues. So thank you for tonight.
Thank you so much for having me. It's always great to share information with an international audience, because I realize not everyone speaks Portuguese and can go to our website and check out what we're doing. So thank you once more, and I'll be happy to continue this conversation in the future. I look forward to speaking again soon. Thank you very much.